There's a tremendous amount of legal uncertainty that people deal with on a regular basis. And the source of that legal uncertainty, or at least a source of that legal uncertainty, is that the law is so freaking complex. The law books are massive, the case law is even bigger, and it's impenetrable to the layperson. But now let me ask you a question. What if AI could synthesize all of it? What if AI could read all the case law and read all the law books and synthesize that and understand your legal situation or the legal context that you're in and give you more or less certain advice about how things would proceed if you went to, say, court on some particular issue, or if you filed your taxes this way versus that way? Wouldn't it be great if AI could do that sort of thing? Now, maybe it can. And I spoke with Abdi Adid about this. Abdi is a visiting associate professor of law at Yale Law School. Maybe you've heard of it. And then an assistant professor of law at the University of Toronto. He also was the co-author of a book with someone named Benjamin Allari. The book is called The Legal Singularity: How Artificial Intelligence Can Make the Law Radically Better. And Abdi and Benjamin argue that AI really can, barring or providing that certain kinds of technological advancements occur, that such that these things get increasingly more accurate, that they will, here's the bold claim now, eliminate legal uncertainty. Big claim. Really interesting too. And the conversation has at least three parts. There's nothing particularly technical that you're going to hear in the conversation to come, but there's three parts that I wanted to draw your attention to so you can navigate this conversation better. The first thing that we talk about, and again, we're putting to the side for the most part concerns about the accuracy of these things. That's obviously, that needs to be solved for. We need this thing to be at least as accurate, if not more accurate than, say, what? Most human lawyers, all human lawyers, which isn't that high of a bar since there's so much text that a lawyer can only know so much at a given time. So what we focus on is, number one, the importance of judgment calls. For instance, there's one issue about how do we apply the law to a given case. That requires a judgment call, or whether some particular kind of action falls under a certain kind of legal category. Was this really a case of negligence, or was this just normal not checking on something, as an example? A second issue that we talk about is what constitutes core legal work. This is really essential because in my head, when I was having this conversation, and probably in most non-lawyers' heads when they're thinking about legal disputes and legal uncertainty, they're thinking about big case law. They're thinking about, I don't know, shows like Suits and The Practice and Law and Order. Am I dating myself? I watch Suits, but I haven't really watched any legal shows other than that in a long time. Anyway, you get the point. But Abdi's point is that there's a tremendous amount of everyday garden variety legal questions to which we ought to have the answers, and to which AI should, in principle, be able to provide those answers with a high degree of certainty. And then at the end of the talk, the third part of our talk, we talk a little bit more broadly about what constitutes a just legal system and the extent to which the system would be improved if the average person had access to a kind of legal AI chatbot or something along those lines. Okay, so that's what this conversation is about. It's really interesting. As you can imagine, Abdi is, being a professor at Yale and Toronto law schools, adept at articulating his position. I do accuse him of holding a bananas position at the beginning, but I don't know, I'm mildly, slowly warming up to the position. At any rate, it's very much worth considering. If you disagree with any of that, or you've got some trenchant criticisms, suggestions for me on who I should have on the podcast next, please email me at em@reedblackman.com. And look, I'm out here singing for my supper. So would it kill you to share the podcast, give it a 5-star review, I don't know, write a review, something along those lines? All right, if not, it's okay. I'll probably forgive you. All right, let's go talk to Abdi.
You have what strikes me on the face of it as I don't know, bananas view that AI is going to usher in the era of legal certainty. It's going to abolish legal uncertainty, which I take it means something along the lines of we're going to know exactly or not whether the law applies. We're going to have clear indicators, no legal gray. There's just clear black and white. Just AI will make the law black and white. That's the thesis.
Yeah, you know what? Just to amp it up even more,
Yeah.
the idea is that with the advent of AI and its application to legal data, we're going to be able to know the law in real time and on demand. So it's going to be the practical elimination of legal uncertainty. Now, the reason that I don't say it's going to be the full elimination, and my co-author Ben Allery doesn't say it's going to be the full elimination of legal uncertainty, is because some uncertainty is by design, right? So there's certain things for which you want specific rules, others for which you want broad standards, especially in situations where you can't anticipate what's coming down the pipeline. For example, think about regulating AI. We might prefer broad standards with some room for uncertainty right now in the rules that we set because we can't hope to anticipate every single AI development going forward. And so if we were to regulate in a way that was so specific, we'd be under inclusive, right? So some uncertainty is going to be endemic to the way that we engage in lawmaking and rulemaking. But the basic idea is very simple, which is right now, the law is pretty elusive, right? And that elusiveness is not by design. That elusiveness is basically because the law is hard to put your finger on for most people in a lot of situations. Part of that has to do with the fact that you need this elaborate education to be the appropriate interlocutor for legal information. But most of it has to do with the fact that what we call the law in a lot of key areas that affect our lives is bound up in all this text. Sometimes it's complicated statutory material. Other times it's case law that you can't point to a specific line and say that's the law. It's all of it, right? The law is derived from the entire corpus. And so it becomes a very difficult exercise for many people, unless you are like us and you have this privileged and ridiculously elaborate education. It's very difficult for most people to access and to understand. And so they end up paying for it significantly for legal advice. And that legal advice isn't guaranteed to be error-free or on point because of how deeply human and enterprise the whole putting your finger on the law thing is. And so imagine this. Imagine that you could, in a matter of seconds, synthesize all of the historical case law and statutory material and secondary information in a specific legal area and bring that to bear on a question that you have. So if you want to answer the question of, I'm a gig economy worker, am I properly classified as an independent contractor or an employee? In the normal course, that would require a lawyer like myself to spend time. We might shoot from the hip to begin with, but we spend some time performing confirmatory research. We read, I don't know, a couple of dozen cases to verify. Even that is a small sampling of the entire case universe. And that reason that we select the sampling is because there's a limit on how many cases we can read in a day. What if we use technology that's inexhaustible, that can synthesize all the historical case law in a matter of seconds and start using that to get us on a higher floor so that I can then reconcile that against my skills and experience and give people a more informed answer as to the question of how they should be classified. That is the basic conceit behind this idea that the law can be predictable. It's using AI, machine learning, generative AI to perform the computational aspects of law in a way where we don't have to do the very difficult placing finger exercise.
Okay, so there's a lot there. So let me see if I have a basic grip on this anyway. Basic is just the law's super complicated. There's 1,000,000,001 laws. There's 1,000,000,001 cases. And any human, well, this is a point that lawyers often bring out. Humans are pretty bad at it. Even the best lawyers can't possibly know all the laws, can't possibly know all the case law, can't possibly know all the rationale, the deliberation behind all of it. It's just too much. And so in comes AI that can handle all that. And so in principle, at least, it should be able to get a grip on all that stuff. You ask it a question and it will tell you, drawing from the set of legal knowledge or something along those lines, what the right answer is. That's the setup, right?
That's the basic setup.
Okay. Now, obviously, there are technical worries or accuracy worries. So when you have things like large language models, they hallucinate, they come up with false outputs. Let's put that to the side, though. I want to put that to the side for a moment. We can come back to it in a second.
Only for now.
Yeah, for now. We'll come back to it. One of the things that strikes me as unavoidable about law is its application. And it doesn't seem to me that the application of the law or the difficulty in applying the law is fundamentally ignorance, although that's one issue. It's just that there are judgment calls to be made. There are things like, is this new case, is this novel case sufficiently similar to the previous cases such that it warrants the same conclusion? We should come to the same conclusion about this case as that previous case or those previous cases. Or is it sufficiently dissimilar in the right sorts of ways such that we ought to come to a different conclusion? Or maybe the same conclusion, but for different reasons as the other case. So given that we've got to make these tough judgment calls about whether this thing is sufficiently similar, how do you do that? It just seems like AI can't do that sort of thing, or if it can, now we're talking about something other than just drawing out the law from the set of medical knowledge that we have. Sorry, set of legal knowledge.
Yeah, I think that's legal knowledge. Yeah. I think that's a very good point. And as a starting point, I like to think about it in terms of, okay, how sure are we that the difficulty we're having in trying to identify correct legal answers is fundamentally because we have to make a judgment call. And how many of these issues are really informational problems and computing power problems. So I happen to believe that quite a lot of the law is actually predictable and should operate more consistently than it does right now if we didn't give up this huge information advantage by refusing to compute some of it. And I'd be quite happy if there was some residual set of questions which were truly edge cases, truly required judgment, and say, let's jealously guard those and make those analog decisions as people because they are new. We want to be thoughtful about the kind of direction that we set the jurisprudence in. We maybe want to agonize in these particular cases over what the right optimal social outcome is. We can use AI as a way to guide us, as a way to take stock of the historical precedent. And then we can mount a social intervention if we want, if the situation calls for it. I'm well aware that if we used a predictive algorithm to determine whether or not separate but equal should remain the law in Topeka, Kansas in 1954, before Brown v. Board was decided, the weight of the historical precedent would have gone in favor of separate but equal. But the court took stock of this and then mounted the social intervention and said, that's not consistent with our evolving social mores and our view of what the law ought to be. All that AI would do here is give us the more intelligent, informed sense of the state of play. And to the extent that we need it to perform a predictive function, it could do so for all these other areas for which the law might actually be that predictable. For example, the question of did someone act negligently such that you could recover against them in torts? Did someone breach a contract?
Sure.
Is there basic classification questions for which there should be a meaningful binary outcome and where we actually do pretend when we engage in the enterprise of judging that it's predictable, right?
I don't know.
That's a huge swath of legal information.
So let me take, I don't know, maybe this is a silly example, but I'm gonna give you an example and we'll see what you think
Sure.
about it. Okay, there's a bunch of kinds of things that I'm wondering about. So here's one kind of thing I'm worrying about is you brought up negligence, I think, whether someone was being negligent. So I think this was the case that I heard when I was back in grad school and I was a TA for philosophy of law. The example was of a butcher who has a bunch of meat in the freezer, and this was bringing out the distinction between negligence and recklessness, where the negligent butcher is the one who checks the temperature of the freezer, thinks it's not really cold enough, and does something to try to fix it, but doesn't really check on it again, and then serves the bad meat. People get sick. That's negligent. Reckless is they don't even check to see the temperature of the freezer to make sure that it's okay. Suppose a butcher does this thing. They serve the meat. People get food poisoning. Let's ramp it up. Somebody dies. Someone says you were negligent in the way in which you stored meat. And they say, I checked it 3 days ago. And maybe, is that negligent? Should it be every day? Are there hard and fast rules about what constitutes negligence? Now, this is a silly little case, but it's meant to be a kind of toy example of there's lots of gray areas where we're not sure whether what they did constitutes negligence or just things happen. How's an AI supposed to tell us where that line is?
It's a good question. So part of this has to do with what do you think judges are doing? What do you think adjudication is about? So it isn't the case that adjudication self-image or the self-image of the judiciary is that they're deciding novel cases that require the synthesis of all social facts and information at all times to mount the normatively desirable outcome, right? It's not that the judge is looking at the ordinary negligence case and saying, I don't have material that's supposed to guide this, and I'm going to make what I think is the socially optimal decision. What judges are purporting to do in those kinds of cases is make a judgment that's as consistent with the precedent as possible. And what the litigants are purporting to do in those kinds of cases is try to locate their best arguments within the corpus of existing precedent. And so all of this is an attempt to leverage predictive analytics and these kinds of newfangled AI tools to better effectuate that outcome. We can say that we want to do judging differently. We want more normative policy-oriented judging. If that's the case, then I would say, yeah, that calls for a reduced role for AI. But to the extent that we're trying to predict, we should be trying to predict in the best way possible. And the advanced data science techniques that are bequeathed to us by our AI world are exactly how to do that. And let me make a point about prediction here. In some ways, prediction is the long-held aspiration of the law, right? You were a TA for philosophy of law. You might have at some point come across Oliver Wendell Holmes. He had this piece in 1897, famous American jurist, had this piece in 1897 called The Path of the Law. It actually started as an address to law students. And he says, the prophecies of what courts are doing and nothing more is what I mean by the law, right? By the way, in that same piece, he also said, the lawyer of the past is the black letter lawyer. The lawyer of the future is the master of statistics and economics. So he was making an early case for interdisciplinarity 3 years ago. But this point about the prophecies of what courts might do being the law it's a basic insight that if you really give it some thought, you realize that a lot of what we're trying to do is make predictions. So if someone knocks on my door and I'm a county lawyer and I've hung up a shingle and they say, hey, I got let go from my job, they'd be really frustrated with me if what I started to do is recite the multi-part test for wrongful dismissal. What they really want to know is, what can I do? Can I get reinstated? What's going to happen to me? What else went wrong? They want you to make a forecast, an educated guess, and based on your experience, more than an educated guess, actually. They want you to make a forecast about what's likely to happen in their case. If someone is charged with a crime, they're not coming to you for your recitation of the Hornbook rule on assault. They want to know, what kind of time am I facing? And so in many ways, what the public anticipates and expects from lawyers is that prediction. So to the extent that we're purporting to do prediction, then we should actually be figuring out ways to use the most state-of-the-art techniques to do so. And one last thing on this. Almost all legal statements are predictive in nature, right? So if I say I own a home, I guess I'm nominally saying my name is on a deed somewhere. What I really mean when I say I own this home is that if it really came down to it, I'm confident that if you started squatting on my property, that authorities would vindicate me. And so almost all legal statements that we make are imbued with some prediction, some forecast as to what future courts are likely to do. And to the extent that we're attempting to do that, there are ways now. We're more capable now of doing that in a way that's more robust when reconciled against human skill and experience.
Yeah, I don't know. There's a lot of things to push back on. First of all, just a sort of nitpicky. I don't think that when I'm saying something is my property, I'm saying my deed is on it or something along those lines. I'm saying that I have a right to it and I have a justified complaint against someone who might take it from me. But I might live in a place where the courts are corrupt or just completely ineffective. And so I know, as a predictive matter, if they steal my stuff, I'm just toast. I don't really have means by which to redress the wrong, but it's a wrong. But saying it's my property is to say that someone would wrong me if they took it. And I can be totally agnostic about the probability of my getting compensation for having been wronged. That's one thing to
I
say.
think, yeah, for sure. Legal claims have an expressive function or a dignitary expressive function. I totally agree with that.
That's not
Except that would be
that's meant
probably,
to be, I suppose it's a normative claim. I have a right to it. People ought not to take it without my permission. If they do, they've done something wrong, so on and so forth.
okay. At the risk of being a great consequentialist on this point, let me ask you this. Do you think that if you told most people that the value, what they can trade in for the quid pro quo associated with their legal claim is that they can indicate to someone that they would be upset that you treading on their property or violating their property right would upset you, right? Most people feel like it has to be tied to some kind of consequence or some kind of recourse.
I'm not saying I'd
right?
be upset. Maybe
Yeah.
the fact that something is my property and someone takes it, maybe I don't even give a shit about it. And so I don't actually
Mhm.
care. Nonetheless, they've wronged me by virtue of having taken my property without my
Interesting.
permission. So I'm not predicting about my level of upsetness. I might be totally Zen Buddha about the whole thing and say, oh, someone stole my property, but such is the way of life. It ebbs and flows and
Mhm.
nothing is permanent, blah, 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 blah. But
I
that's
agree
not
with
me
you. I agree with
saying,
you as a matter
therefore,
of
it's not my
general
property.
principles. I do agree with that.
All right, so I want to get back. That's a nitpicky point, but made by me, though. I want to get back to the core of it. To get this consistency point, we want to provide judgments about cases that are consistent with the cases that came before, unless we're talking about major social upheaval, like you were talking about earlier about separate but equal. Fine, fair enough. But what does it mean to be consistent with the previous cases? Because does consistent mean literally all of the, let's use a fancy word, non-normative facts are the same? Does it mean most of the non-normative facts are the same? Does it mean only all the relevant non-normative facts are the same? Okay, but what do you mean relevant? Or what constitutes as a relevant fact is going to be a judgment call. It might, someone might think something is relevant when in fact it's not relevant. Let's take sentencing guidelines. I don't know. Someone says, oh, he was, beaten as a child and that's why he assaulted that. We should take that into account. That's relevant to the sentencing. And somebody else says, that's irrelevant. Well, he's a grown man now. That was 20 years ago, and that's a shame that happened to him. That he was beaten up by his parents, but he's fully mature adult now, responsible for his actions. And so that is not relevant
Yeah.
to sentencing. And that's just one example. My point is that
Yeah.
whether it's relevant or not depends upon certain kind of judgment calls, and it's not a black and white legal issue. It's not a function of ignorance, right? If you say his being beaten as a child is relevant and I say it's irrelevant, I don't think either one of us are suffering from ignorance of the law with which AI could help us.
Yeah, I don't actually think ignorance is the core problem in general. I don't think ignorance is the core.
But
Because
isn't that what AI is supposed to do? It's supposed to draw from this vast amount of the set of legal knowledge and confer upon us the appropriate legal facts at the time in real time so that we know what's going to happen next?
Yes. So part of what it purports to offer is that vision, but that's not solving a problem of ignorance. It's often solving a problem of speed, efficacy, computing power,
Mm,
accuracy. Ignorance is not always the issue. Sometimes ignorance can be the issue when you're talking about, if I imagine myself to be a non-lawyer
sure, sure.
layperson and I might misapprehend the law, being able to run an AI, some kind of algorithmic prediction to tell me where I might run afoul of the
Mhm.
law, that can help to resolve the ignorance problem. But for the most part, are talking about leveraging these tools to better help us better operate the system to meet people's general needs. And if that means being able to bring down the research and investigation costs on a given legal claim so that you can support yet more people, or if it means reducing the likelihood of inaccuracy so that the quality of the legal advice is substantively improved, these are the kinds of things that I think it's attempting to resolve. On the point about consistency, though, I think it's a very good question. So most of what we mean by consistency in the law is that similar situations ought to be treated similarly,
Sure.
assuming some overlap in the factual matrix. Now, the challenge here, of course, is how much overlap does there have to be? Which facts have to be the same? And part of the hope here is that if you are able to engage more computationally with the law and able to make these predictions, then it might lay bare the extent to which we have radical inconsistencies in our system. Just as an empirical method, it might shine light on
Sure.
the fact that there's significant inconsistency, and then we can coalesce around a goal of more consistency or decide that normatively we don't actually desire consistency. So part of what I think AI is doing is bringing the issues into stark relief. How accurate have we been? How consistent have we been over time? And then the question about which facts have to overlap or what constitutes a relevant fact, we're supposed to have in the law interpretive principles to determine these things. They're not supposed to be resolved through some a priori reasoning, right? It's like there has to be a principle to determine what constitutes a relevant fact. Usually it's delimited or scoped out by case law. And so
Mhm.
it should theoretically be in there. The principle for what constitutes relevance, for instance, in a
I,
given context. These are broad and amorphous standards, but they have to have source material in the law. And so all that AI is trying to do is make sense of what exists in the existing expanse of information and try to excavate that for our purposes. We can manipulate it and use it and do our jujitsu moves thereafter, but let's unearth more of it faster and better in ways that can be for our use.
so maybe this is a stupid question, but I'll go for it. Okay, so what you're saying, I think, is that there are laws about whatever, if you like, first order legal issues, and then there are embedded in the legal world rules or principles about how to apply those laws, something along those lines,
Yeah.
right? And of course, then what I want to do is I want to do the philosopher's move and say, okay, but what about those meta rules that tell you how to apply those first order rules? Don't we need rules for how to apply those things? And are we going to have judgment calls about whether this rule about how to apply this thing applies to this particular case or not? And so we're just moving the dispute to another level. We're not removing the dispute. We're not removing the judgment call. The appeal to, oh, there were rules about how to apply these laws. It makes it look like a kind of sort of simple binary mechanistic process when in fact it's just more judgment calls, judgment making, reasoning, rationality, et cetera, et cetera.
Yeah. But there's reasoning and rationality and judgment calls all the way down.
Yeah.
Like the
Yes.
last
That's
thing I
my
want to
point.
do is, yeah, no, I totally agree with you. But the ones that are dispositive of outcomes and affect people's lives, we should just at least be sure that they're bona fide judgment calls and not just problems of poor computation or insufficient speed,
Okay.
right? Or inaccuracy. And so let me give an example. Okay, let's just stick to the example of the worker being an independent contractor or an
Yeah.
employee, right? That is a what you might consider, just to use a term of art, like a touch and feel kind of analysis. So is an Uber driver a worker, an independent contractor? We'll look at a list of non-exhaustive factors pulled from a bunch of cases. If we're doing a labor law inquiry or a tax inquiry, we'll just pull from hundreds and hundreds of cases, maybe thousands of
Sure.
cases that have weighed in on this. And the cases deal with all kinds of heterogeneous facts. So in one case, it might be a pizza delivery driver. Another one, it's a FedEx driver. Another one, it's a bookkeeper that works part-time,
Yeah.
et cetera,
Yeah.
right?
Yeah.
Let's just say there's no one case for a gig driver that works in a tech
Yeah.
platform.
Yeah.
So you don't
Sure.
have a pattern match case. And so the relative salience of factors in that is going to change. You might have 7 factors. Do they wear a uniform? Do they use their own equipment? Do they participate in the downside risk of the enterprise? Do they set their own hours? Do they, et cetera,
Sure.
right?
Sure.
Can
Sure.
they take on outside
Yeah.
work,
Yeah.
right? In the FedEx case, the uniform might have been an issue, the big issue. In the bookkeeper case, the big issue might have been, did you use your own equipment?
Mm-hmm.
In the case involving the part-time partner, it might be, did you participate in the downside risk of the operation? So you just don't have anything that coheres as like an obvious
Necessary and
set
sufficient
of
conditions. Yeah.
Yeah, exactly. You just have a collision of a bunch of non-exhaustive
Yep.
factors in the case law. Okay. Now, if someone asked me that question, let's imagine I'm a non-expert legal generalist. Someone asked me the question of how should I classify my workers? Here's what they do. I would do what all good lawyers do. I would say it depends. And then I would go and I would perform some confirmatory research. Now, the rate limiting factor on the quality of advice that I could give is how much of that universe of salient legal material that is still valid precedent I'm able to access,
Mm-hmm.
right? I use the word access here because it could be quite literally an issue of access.
Mm.
So maybe I just don't have the resources to be able to access the relevant corpus of precedent.
Right.
But even if I do, maybe the rate limiting factor is how many hours in a day, how many other cases I can look
Sure.
at,
You
et
got
cetera.
limited bandwidth. Yeah.
So if I could leverage AI just to solve the blank page problem in that question, and in a matter of seconds, be able to synthesize all the historical case lines, surface for me the most relevant ones that I would have had to read anyway, probably,
Mm-hmm.
except I would have had to do it as per my own devices. Then the basic insight is I'm starting off on a higher floor. Now, what's left for me is to reconcile that against my skills, my experience, my knowledge of the local context, my sense of the particular canons of interpretation, or what this judge might like, or what has tended to go right in our particular jurisdiction. Now, AI can assist with some of those things as empirical method, but it's not going to be the full turnkey solution. But what it might do is give me a sense of what kinds of claims are likely to be winners and losers, such that it can reduce the incidence of, say, frivolous suits. Or even if a suit is frivolous or it's the kind of that might not succeed, you bring it for good reason, not just to clog up the gears in the system, but you bring it because there's some dignitary expressive interest. You want to hold your wrongdoer to account, right?
Sure.
As opposed to you're bringing a loser case because you've misapprehended the likelihood of success. And so there's a little bit of predictive function, there's a little bit of actuarial method. And then there's the thing, which is, even if I want to do it the old analog way, and in the end, I want to make the discretionary judgment call that's based on what I think is the normatively desirable outcome, I do so at least with all the information advantage that AI can give. So you mentioned criminal sentencing earlier, and that's a curious case for me because I think the idea of criminal sentencing kind of lays bare some of the limits of techno critique, right? So there's a lot of things that people say, for instance, about whether AI should be applied in certain legal settings based on its current capacity to do things well or not,
Mhm.
right? Has a propensity to hallucinate, it can embed bias. And that's the reason for being against using AI in certain settings, right? Let's not use AI for predicting people's wages because it's going to embed too much gender bias. I agree with that.
Sure.
And that's the precise reason, for example, that I will never be in favor of using AI in the context of criminal sentencing. It's not because the AI is ineffective right now. It's that even if the AI became perfect, it got to a place where it could totally eliminate bias, have no hallucination, could perform at a level that's more effective than human beings, could give us what we have decided in some mythical consensus is a socially optimal sentencing outcome, optimal deterrence. I still wouldn't be in favor of AI or algorithmic criminal sentencing because I have a view on criminal sentencing that has nothing to do with what technology has to offer, which is I think it ought to be a hard decision. That's a collective human
I
choice,
see. Yeah,
right?
sure.
If we're going to put people in prison, we should agonize over it. We should struggle. I don't want to optimize or make that faster.
Yeah.
I don't even know that I want to make that more accurate. And by the way, the things that are most important to me in that context are a bunch of quote unquote non-legal inputs, things that don't get flattened to ones and zeros, like your subjective sense of the person's potential or your view of mercy. And we should have those objections to the application of AI in a bunch of different settings, but they can't just be premised on what the AI can do today, because you have to believe that some of the smartest and also most evil people in the world have a perfect interest convergence around improving the AI. And so it's just going to be better over time. And so any objection to what it can do today, that's going to fall away. So what are our real reasons for objecting? I have one in context of criminal sentencing. And so how many more of those do we have?
Yeah, I could talk about that issue probably all day. I've talked about it with some other people as well on the podcast about, yeah, maybe there are some kinds of decisions for which we just want humans deliberating, and that there's value in the humans deliberating about that kind of thing. And we're talking about sentencing in particular, and even finding guilty or not guilty, you might think.
Totally.
even if we get AI to be more accurate, that needs to be weighed against the value of people taking each other seriously enough to agonize over whether they're guilty or innocent, that sort of thing. Okay. But
Totally.
let's put that to the side. That's just me registering the point, and I think it's a really important, interesting one. Okay. So now I'm beginning to think, and I want you to disabuse me of this, that your thesis is actually less dramatic than one might suppose from the claim that it's eliminating or has the potential to eliminate legal certainty. So, because look, Reed, what I'm saying is that those lawyers don't need either, if they're sole practitioners, they don't need to pour through all the cases in the law. If you're at a big law firm and you've got your first, second year lawyers right out of law school, digging into the books. I just watched Suits, doing all that deep research. You don't need that anymore. We can have AI do that stuff, summarize, analyze, make recommendations. It's going to do it really well. And so it's going to be a huge assist for more senior level lawyers, judges, etc. And then I say, yeah, that sounds plausible. Again, to your point, there's hallucinations, there's this, there's that. Fine. Okay, let's put the accuracy, technical stuff to the side, because we don't actually know how good it's going to get. Let's assume for the sake of argument, it gets phenomenally good, or at least it doesn't have to be. Just do a lot better than us, or better than us, which is a low bar because we stink. So,
We suck, yeah.
So we're on the same page on that. That's good. But this now seems to be just far less dramatic. What am I failing to appreciate in saying, yeah, you're right, it's going to speed some things up? But there seems to be a gap between that claim and eliminating legal uncertainty. So what's the nature of that gap and how we're supposed to fill it?
Yeah, we're taking different views on what core legal work is or what core legal analysis is.
I said I watched Suits, so I think I know. Thank you very much.
Hey, it makes you an expert. By
Obviously.
the way, the show that's actually decently accurate is The Good Wife.
Oh, okay.
And The Good Fight After, even though they definitely have a thing where they go to trial like later that afternoon, or the same lawyer will do the wills and will do the corporate merger and does a divorce.
Yeah.
But not bad, actually.
All right, I'm going to reach out and see if they want to sponsor the podcast now.
Yeah, you can play this clip for them. The point that I'm making here is that, okay, if you think about, let's think about what law, we're going to really get philosophical here. Let's think about what law is and does, right? There's a vanishingly small percentage of legal questions which end up in disputes. And there's an even smaller amount that of those disputes that end up getting resolved on any kind of merits determination.
What is that? Sorry.
A lot of what happens is
what does it mean they don't get resolved on a merits-based, whatever you just said?
Okay, so if law is everywhere all the time, there's a copyright claim that you're going to make in this podcast, or you'll hold a copyright in this podcast or something, and there's a building code that operates on it. There's just law everywhere all the time.
Yeah, sure.
And some of those will end up in disputes that become adversarial.
Sure.
Where I say, actually, I want to reproduce and post this podcast everywhere and call it the Abdi Show as opposed to your show.
Yeah, sure.
Right. And then we have an issue, right? That's a very small percentage of the social activity that implicates the law. It becomes a dispute. And then from there, a really small subset of those end up becoming adjudicated based on who was right.
Yeah.
Most of what happens, the law is what scholars Kornheiser and Mnuchin call bargaining in the shadow of the law, right? Where you and I, if we're making competing legal claims, let's say we're negotiating over something, we're taking competing views on what the law says as part of our sort of negotiating position.
Okay.
So you and I are trying to, actually the example I used was divorce and like asset distribution.
Okay.
And they were saying the parties are not in court, they're negotiating outside of court, and they're having a conversation, but each of them, the beginning and end of what they view to be their leverage is premised on what they think a court is going to vindicate, what view they think a court is going to vindicate.
Yep.
And so the person who has the AI big mechanical assist that tells them that in these situations, courts will 98% of the time go with you, that person has all the leverage and they can drive a hard bargain or they can walk away absolutely confident that their position is going to be vindicated in the future.
Mm-hmm.
On the other side, if the person doesn't have that information advantage, they might misapprehend their negotiating position and then take a non-optimal path to the courthouse and then lose, right?
Okay.
For disputes that don't end up in court, a lot of it is us having competing positions as to what the law is. That's one building block of this picture. The other component of it is all of us engaging in all manner of social activity with the expectation that it is either legal or with the expectation that if it flouts the law, it's not the kind of thing that's likely to be enforced, or we're making some assessment about enforcement risk. Okay. Most people are engaging with the law in that way. They just think what they're doing is either okay or it's not okay and they don't care, or it's
Yeah.
not okay and they have realistically appraised the risk and are okay with it. Okay.
Okay.
Most of those questions are garden variety legal issue. Can I take this deduction or not? Can I build my house on this lot or not?
Mm.
Can I encroach on my neighbor's property in this way or not? Can I purchase this illicit drug through the mail? All these things.
Yeah.
Those, those for the most part ought to be utterly predictable to us in our system
Hmm.
because they enable or dissuade behavior that is normal and should probably just flow and
Yeah.
continue.
Things like
Okay.
we should know the speed
The
limit.
ones
Right.
we should know the speed limit. And there's a reason that we say for the speed limit, drive 40 miles an hour as opposed to we say proceed reasonably safely. Because you don't want people to be making judgments moment to
Yeah. Sure.
moment.
Sure.
You want a cut point rule. So it's easy to say, hey, you're driving 41, you're in violation of the law. No additional context changes that determination. Most of life ought to be in that predictable form.
Hmm.
Okay. And actually, the legal system presumes that most things are not the kind of big, normative, policy oriented questions that implicate morality. It's in my view, a small subset of cases. And actually, if our courts could focus on those cases, we might be better off. If it is the case that we could reserve our judiciary where we appoint these quasi philosopher kings to make their wise judgments, why don't we reserve the really hard stuff for them as opposed to clogging their docket with a really difficult constitutional case, but then also a petty dispute between neighbors, right?
Okay.
If we can automate more and more of the cases that ought to be predictable to us, that society actually benefits from having more predictability for, then maybe we can actually reserve our courts for the difficult edge cases.
Okay. Let me see if I got
Yeah.
all this. So I like this, but I appreciate spelling out the picture. So it's something like 1% of cases are interestingly contentious. And then even a subset of that 1% is the one that actually get tried in court or whatever it is, where people are actually going to get to the table. So we think about the law, application of the law, we have in our mind the good wife and the good fight and suits
Yeah.
and things like that. But that's such a tiny fraction of the actual legally relevant activity that goes on. For 99% of the time, what's going on are all the things that you just said. Am I going too fast? Can I file this as an expense for my sole proprietorship? I don't know, whatever it is. Can I buy this house this way? Can I file it?
Yeah.
But okay. So we've got all these sort of non-high stakes legal decisions.
Yeah.
And people wonder about this stuff, or they might wonder about this stuff, and we can get them so that they don't have to worry about that stuff. So
Ooh.
the elimination of legal uncertainty is really about the elimination of legal uncertainty for the 99% of relatively low stakes garden variety legal questions.
Yeah, it's the practical elimination of legal uncertainty for most people. And it's the recognition that there's some uncertainty that's unavoidable. So let's just create some triaging or a high threshold to decide which ones are truly about uncertainty and which ones are just informational problems or ignorant problems or inaccuracy problems.
One of the things that you pointed out is that, oh, it's going to show that 98%, this was the divorce case, 98% of the time you're going to win that claim. And so they know that, blah, blah, blah. I have to imagine that given the sort of, I don't know, legal patchwork that we have, especially in the US, I don't know what it's like in Canada, but across the US, there's different districts, there's different regions, there's different states, there's different politics, there's different blah, 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 blah. And it's going to be one, maybe you can get the AI to be specific enough. Hey, listen, I live in Georgia, USA, and this is the issue, blah, 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 blah. But I also imagine that there's going to be still a lot of variety where it's going to be like 60-40, 75-25. And so now we're not in the realm of legal certainty. We're in the legal realm of legal probability. And I guess it's an empirical question that I'm asking you, which I know that you probably can't answer, although maybe you can. What's the set of those of the 99% that are garden variety legal? What percent of those are really, yeah, it's 98% that we know the answer, as opposed to 50-50, 60-40, et cetera.
No, that's not a question I can actually answer. I don't actually know which percentage. It's an empirical question.
Yeah.
That would require a lot of study. Let me say this though,
Yeah.
because this is interesting. Within an easy legal question, there could be a 51-49 split. So for example, the question of, I'm trying to think of a simple enough issue. Let's take an ordinary tort or something. Look, the question of, did someone commit battery, right? Now, the rules around battery are ascertainable. We know what constitutes a battery. We know exactly what the universal precedent around battery is. And so it's not the kind of legal issue that is imbued with the same kind of uncertainty as a, say, legal question related to how do we classify cryptocurrencies, because we haven't yet developed some case law on
Yeah.
that, right? So we're dealing with a situation where there's some productive source material, right? There's the law has performed its information service for us, and now it's a question of how we fashion our arguments, right? The actual real world situation that led to the battery could be an edge case. It could be a 5149, right? It could be that one person is claiming that there was this unreasonable intrusion on their physical person that led to unwanted touch, harmful and offensive touching without consent. The other person could say, hey, the operative term here, consent. I take a different view of the social situation. There's some notions of implicit consent, and
Right.
maybe at worst I misread the
Yeah.
situation. That's a bona fide dispute. That's what adjudication is for.
Mm.
Right? What you don't want is cases where one side or both sides have totally misapprehended let's call it the actuarial stakes, where they're equally strident. And maybe this is the kind of case that ought to have settled, or we have some other recourse for. And the point is that this is maybe a first step towards decluttering. Maybe it's a first step towards a recognition that having a higher sort of ordinal ranking of what constitutes like an important case for our society to try to resolve. We're talking here, and you're right, there's more modesty in the claim than I like to let on in the beginning, but we're talking here about some kind of like intelligent, data-driven triage as part of the overall fight for access
Yeah.
to justice, so to speak.
Yeah, it feels like there's a lot of empirical variables at play here. I could see this my AI versus your AI. That's one kind of thing that I have in the
Yes.
background. Also, these sort of predictions like, oh, if we right now the highway is 2 lanes, but if we increase it to 3 lanes, we'll free it up. And it turns out that does nothing to help traffic, just means more people get on the road driving.
Yeah.
Oh, now
Induced demand.
okay, so now we create this sort of legal AI legal counselor to everyone. Does that decrease the extent to which people seek legal guidance and go to war, so to speak, legally with somebody else? Or does it increase it because now everyone's got their AI lawyer who can spin things this way or that way? I don't know how that works out at the end of the day.
Yeah. So this is a great question. I like to think of it this way. Okay, if everyone had AI, would we just bring more frivolous cases? Or would we just clutter the courts further because the costs of participating are
Exactly.
low?
Yeah. Yep.
So for
Can you
me,
file
it's
this form
pretty
for me?
clear
Right
that
now, it's so hard to file a form to know where to file it. So imagine I'm just someone off
yeah.
the street. I don't know what form is relevant. I don't know how to fill it out. I don't know if I did fill it out, where to file it. And then I tell the AI, what's the relevant form? Can you fill it out for me with, here are the details. Ask me the questions I need to know. Fill out the form. Now please go file it or tell me how to file it. I never could have done that before. Now I can do it.
So for me, and this is a personal view, and I actually would love to hear your thoughts. I quite clearly prefer a situation where our courts get overloaded because people are capable of litigating their claims, then our courts are overloaded because some people are capable of litigating their claims and a whole swath of others. The only thing that's keeping the courts alive is the fact that there's a whole bunch of people who have an informational or resource disadvantage or a educational disadvantage or a language barrier
Yeah.
or other kind of structural barrier preventing them. For me, it's one of those things where it's okay. It would be a great problem to have if we had this utterly accessible legal system and then we had to decide different ways to cope with it. Now, the reason that I would prefer that outcome is because maybe it might spur some reconsideration of the way that we resolve disputes, but also the fact that I think that there's going to be speed and efficiency gains just by dint of it being AI that we use,
Mm-hmm.
right? In the same way that the AI can make pleading a claim faster, it can also make resolving a claim faster, right? And so the medicine is in the diagnosis in some ways in those kind of situations. But the core point that I want to make here is if that's an untenable outcome, then that's the kind of untenable outcome that I want us to have so that we can think about adequate ways to reconfigure, because the kind of untenable outcome that we have right now is one that depends on the attrition of a whole bunch of people who should otherwise have justice.
Yeah. So I like this point that basically you're saying something like, hey, Reed, isn't it super unjust that there are people who aren't filing lawsuits, are protecting their legal rights because they lack the capacities, whether they're mental or financial or whatever their limits are? Isn't that a shitty situation? Shouldn't we? And most anything would be better than that. Yeah, fair enough. Okay. But I also think you're beginning to go down a path that I think you don't want to go down, which is what's going to be the answer to all those new lawsuits? If it generates thousands, millions of new lawsuits, how the hell are we going to handle that influx? Are we in a better situation than before? In some sense, maybe, sort of in principle. Pragmatically, I'm not sure that we are, because all those people who couldn't have access before, now can file lawsuits. They can file lawsuits now, hooray, but they never get heard because the justice system is now creaking to almost a grinding halt. I'm not sure that pragmatically we get the upshot that we want, which is actually getting those people with limited resources the justice that they deserve, because the justice system isn't built for that. So then what do we do in order to accommodate that? Now we're going to have AI judges adjudicating the various things. But that's exactly what you said you didn't want. You wanted people agonizing over legal disputes. But it might be the case that
certain kinds,
Okay,
people agonizing over certain kinds of legal
okay, so we
disputes.
can't have AI judges in some cases then, and the 99% of
Certainly
authority.
not. So there's two categories of cases where you AI is a bad fit for dispute resolution, right? So one category is the kinds of cases that take significant stock of non-legal input. For example, are we ever going to have a AI, some predictive judging for a constitutional legal question? I don't know. Things like prevailing political winds and
Yeah,
social
sure.
ethos and changing evolving norms. Those things are non-legal inputs that matter for those kinds of questions, right? Then there's one where just the AI practically, as it stands right now, it isn't parsimonious enough or sensitive enough to the kind of inputs. And there's another category, which is the ones that we just think as a matter of public policy, or even as a matter of, dare I say, justice. We think that it ought to be a collective human responsibility, right? So I think of like criminal adjudication, criminal sentencing as one example, because the social significance and the moral weight of those decisions are so high that I just think people have to be implicated in it in ways they can't abstract away from. Maybe I also believe that human beings should also have to be the ones that press buttons to launch missiles, as opposed to that being done algorithmically, because I think the social concept of abstracting away from the human choice loses some significant sort of moral culpability we need for actual accountability. So but on this point about, okay, let's say we clog all the courts. It's the way I liken this, and I hope people think about it this way. Right now, what we do in civil justice and criminal justice in our courts is we say things like, I know everyone has a right to education, but if everyone went to school, we need a certain level of truancy, because everyone went to school, we need to get more desks. We need to have more teachers. For me, it's not that we're in a bad place in both circumstances. If we're in a bad place in both circumstances, but one is fundamentally less just than the other in that it delivers, it fails to deliver on what is purportedly a social guarantee, which is the access to justice, right? Yeah, I just think we should have to resolve the question of overcrowded schools by building more schools and maybe having more teachers and having more desks and having more books. And the question of what the teachers look like, the desks look like, and what the books look like, and whether those are going to be virtual is a sort of second order question.
That's a true academics response. Because
why do you say that?
Here's why I say it. Here I am. My name's Bob. I'm in poverty, more or less. I don't have access to education, blah, 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 blah. And let's just say the law. And I say, I can't file a lawsuit. I don't have access to a lawyer. I can't do any of that stuff. And then you come around and you say, hey, you push this button and it's going to fill out the form. It's going to file the lawsuit. And I say, great. I hit the button. And then it says, okay, your case will be seen in 10,000 years. From your perspective, that's you saying it's a more just situation because now you have access to a lawyer or quasi lawyer or whatever. And now you can submit your appeal or submit your lawsuit, whatever. But here I am, Bob, and I'm just like, that's great. I'm glad you feel better about me being able to push that button, but it has made zero difference in my life.
Yeah.
Zero. Fine. If you want to say, according to some abstract conception of what constitutes a more just world, it's a more just world. Okay, fine. But somehow it manages to be more just and not any better than it was before. Not for me anyway.
Yeah, I would never disagree that that's illusory access to justice. It's not real.
Yeah, that's my point.
I wouldn't disagree. I'm amazed by how generally okay we are with saying we're okay with structural barriers precluding people from accessing justice, but we're not okay with administrative impracticability or overwhelming.
No.
For me,
it's all bad, but I just don't think that systematic injustice is any worse, normatively speaking, in a case in which someone is treated unjustly than a non-systematic unjust action. Here I am again. I'm Bob. I get killed by some random person. I get murdered. Really unjust. If I get murdered by someone who's systematically murdering people, my wrong hasn't been mitigated. Or is it any worse? My being killed is any worse because it was done systematically or something like that. It's still just as wrong because of the scaling issue. It's the scale of the wrongs. It's the quantity of wrongs, not the severity of the wrongness in each individual instance.
Systematicity is bad. I totally agree with you. To the person who's killed, it's all the same.
Yeah.
It's no justice anyway, whether I decide not to file the lawsuit, whether I file a lawsuit, it's never going to be heard.
Yeah.
But the response that should stimulate from the system is different. The response to those things stimulate from the system is different. If we say we're burdened by the sheer amount of lawsuits, right? that might counsel a different kind of response. Our
Of
whole access to
course.
justice
Yeah, yeah,
discourse
yeah.
might have developed
Yeah.
differently than the way it does right now when it's based on structural barriers, right? Like maybe we actually could be motivated to resolve the processing problem.
Yes.
And
Okay.
that could spur the use of technology. Yeah.
100%. I agree. So I agree with all that. Of
Yeah.
course, it's in some sense in advance. We made some kind of move, as it were, down the field, or
Mhm.
at least laterally, so
Maybe,
that we can figure
maybe.
out a better way to go down the field. Okay, so I get that. But then I start worrying about this other scenario in which, okay, we've got all these AI judges deliberating, quote unquote, deliberating about all these different kinds of garden variety cases. And it's going to happen so fast and be ultimately opaque, I think. So I'm going to hit my button. Here I am, Bob. I hit my button, file my claim. They hit their button on the other side and says, "You lost." And I'm like, "What the fuck just happened? What just happened?"
Yeah,
And then they
yeah.
give me an explanation in legalese or whatever. And I'm like, "I don't know what that means." Or they translate the legalese to plain English. And I'm like, "That wasn't
Oh,
satisfying."
totally.
And then this is
Totally.
compounded by the more, I don't know if this is a technical problem with AI as it exists now, but it doesn't reason, right? It doesn't engage in reasoning. It's next word prediction. It's complicated, but its purported explanations for its outputs are not explanations because it's not a reasoning machine. It's not an evidence weighing machine. It's just not that kind of thing. And what's even worse, you want to talk about illusory justice. I get an explanation for why I lost my lawsuit, but the explanation is completely illusory because it's not the kind of thing that can give me true explanations.
Okay, so we can go down the epistemology
Yeah, we
route
could talk
now if
for,
you
yeah,
want
yeah,
to
yeah.
on this one. Yeah. So I'm gonna move quickly off this point, but I just want to put a pin in
Fair.
it, which is this idea of reason given in the law. Okay. So if all that generative AI does is a probabilistic determination of the next likely word, then as a matter of fact, it's not engaging in anything that I would call reasoning.
Sure.
But if you marry the language model to a knowledge model and we say, hey, with respect to Abby and Reed's dispute, their personal injury dispute, use all of the generative language capacity of the sum total of the internet, right? Like a GPT model, but cabin your factual assertions to this corpus of case law in New York
Sure,
related to
sure, yeah.
personal injury, right? Let's say we do that. We marry the language model with the knowledge model. And it comes up with a set of reasons for why we use some machine learning for the predictive capacity, with help with a set of reasons using generative AI for the judgment, right? If that judgment looks, smells, feels like the kind of judgment that I might get from a judge that's presiding over a personal injury case, the actual mechanics of how it reasoned, I'm not sure matter to me,
Yeah.
right? I'm going to move on from this
Sure. Yeah.
really
Yeah. Yeah.
quickly
We
because
can
it
talk
folds
about
into
this for another
folds
hour.
over,
Yeah.
yeah,
Yeah.
it folds into a larger point. And by the way, what that has done is it has eliminated the propensity for ex post facto justification that sometimes happens in the law, like reasoning backwards from what the likely outcome is. And that could be something that's delimited by political, ideological, philosophical perspectives that might be separate and apart from what the supposed universe of source material is supposed to be for a case like that. Neither here nor there. Okay. On this point about AI judging, this is maybe my favorite conversation in this context, because I don't think this singularity ideal where we're going to eliminate practical uncertainty and the law is going to be noble everywhere on demand. I don't know if that's a short or medium term proposition. Part of why I say this is
I don't even know if
because
it's a long term one, but go on. Yeah.
yeah, you might not agree that it's even a long term
Yeah.
one, and there's something aspirational in it, right? And in that I think it can motivate the right set of policy choices, and whether we actually arrive there is up to us in many ways. But on this idea of this not having a linear trajectory, the law is not going to be immune from the broader issues happening in the world of, say, AI, where we're going to have a messy interregnum where we haven't yet worked out what constitutes quality. We haven't yet erected the right barriers to entry for certain market participants so that we can assure that there's the sort of the right intentions and the right level of know-how. The best analogy I can use here is the cost of developing a retail website in the late 1990s is like $250,000, let's say. And today you can go on Squarespace or Wix or Google Sites and build a serviceable, workmanlike website that doesn't embarrass you for $9.99 a month, right? But along the way, we had, between that design studio making you the $250,000 website and you being able to have the Squarespace website today, along the way we had, remember, like GeoCity and AngelFire,
Yeah.
Blogspot.
Yeah. Sure.
We had websites you would go to and it would play music immediately when you log on,
Yeah.
Flash player. And it was just a miserable experience. It took a long time before there were market players that consolidated quality and were able to economize and bring that down
Sure.
to a rate. And before the public consciousness insisted on a certain level of quality. Right now, there's very little variation in the browsing experience for most people. whether you're a technical expert or a kid that's learning how to use a computer in second grade, for the most part, we flatten quality and it's pretty good. It's going to take a long time before we get there in the world of AI. And the risk in the legal setting is that the stakes are really high for the experimentation, right? And so until, if you go on GPT store right now and search legal or law, you'll find a lot of random, unregulated, not that thoughtful attempts at doing what I'm describing, at trying to create predictive legal tools or to use generative AI for legal questions. And we have really no way to work out some of the quality issues because we have nothing approaching a social consensus yet on what an AI legal tool ought to look like. And so the trajectory is not linear. There's all kinds of bouncy, messy stuff, but hopefully in the medium term, some of those quality issues are consolidated. And then we're having a different conversation about how much we want this to come about as opposed to how much is technically possible.
All right, Abdi, this has been super fun. You're going to have to come back on and we're going to argue about more stuff.
Yeah. I would love to talk about, did AI really know anything?
Oh, no. The answer is no. Next question.
Of course not.
Done.
Okay, we agree on that one. Then. We don't have to talk about it.
All right, thanks, Abdi. Let's do this again sometime.
Thanks.
Thanks so much, everyone, for listening. And now let me thank the people who have made this podcast possible. So first of all, we have Delano Alexander. He's been with me since day one. He showed me even how to start recording a podcast in the first place. He does editing stuff. He's been fantastic, and he does really everything I ask him to and more. I've never met anyone else who just says so much. Yeah, I don't know how to do that, but I'll figure it out. What more could you ask for in a producer? Next up, Jennifer Strong, my podcast guru. I don't know what else to call her. She just has advised me on how to design the podcast, how to grow it, and she's responsible for, if you like, this kind of season 2 relaunch and everything around it. So thank you to you, Jennifer. Next up, Meg Marco, responsible for all the excellent artwork. Before I did the artwork, I didn't really know what I was doing. We put it together. It worked well enough, but I think Meg really did a phenomenal job bringing everything together. Garrett Lang, sound engineer that I frankly don't deserve. He's just too good for this podcast. Don't tell him I said that, though. Next up, Benjamin Koltgen. He is a professor of philosophy who has helped me source guests, identify who's interesting, who has things to say, etc., etc. So without him, I wouldn't have anyone to talk to. And then finally, Ashley Wasylenko, who helps with all manner of administrative things, making sure that the podcast guests find their way to the podcast, can schedule the recording, get their bios and headshots, and really just keeping the show on the rails and me organized. Thanks to all of you. Really appreciate all your hard work.